Good evening. My name is Diane Desierto. I am Professor of Law and Global Affairs and Faculty Director of the LLM and International Human Rights Law program at Notre Dame Law School, with a joint appointment at the Keough School of Global Affairs at the University of Notre Dame. I am one of the principal investigators of the Notre Dame Reparations Design and Compliance Lab, and tonight we are fortunate to be able to report through my colleague, Professor Anibal Perez-Lignan, and through an invited guest, Professor Olufemi Taiwo, on the status of our findings in regard to reparations compliance and to discuss inputs regarding criteria for the possible design of reparations, most especially in frontier issues involving climate change, which Professor Taiwo will speak about here tonight. So the sequence for our presentations or our discussions today will be as follows. First, Professor Anibal Perez-Lignan, who is our principal investigator here at the Notre Dame Reparations Lab. He is Professor of Political Science and Global Affairs and at the Keough School of Global Affairs here at the University of Notre Dame. He will present some of the key findings of the lab, particularly in regard to compliance with reparations and reparative judgments, orders of the Inter-American Court and the Inter-American Commission. He will be joined by two of our students, current and former students, who assisted heavily in the preparation of data sets that are now going to be publicly launched, courtesy of the Notre Dame Reparations Lab. Subsequent to that discussion, I will carry on the discussion by examining the current architecture of reparations design in international law and human rights, why we have uneven practices as between different international courts and tribunals, and why we still have, to this day, trouble conceptualizing, let alone tailoring reparations for the kind of wrongs in human rights and in international law that we face in today's global system. This comes into sharp relief, most importantly, in the context of climate reparations. And for this, we are particularly grateful that we have Professor Olufemi Taiwo, who is Assistant Professor of Philosophy at Georgetown University. He has an exceptional book coming out, Reconsidering Reparations, coming out in January. He's also a published author in regard to climate reparations, with one of his pieces lately having been published at Foreign Policy. So we're up tonight for an excellent discussion. Without further ado, I'm going to turn to my colleague and dear friend, Professor Anibal Perez-Lignan, for our findings at the Reparations Lab.
Thank you, Diane. It's wonderful to be here. And I want to thank everyone who is with us this evening. What we are going to do, as Diane mentioned, is that in the first part of this presentation, we will offer an introduction to the work of the Notre Dame Reparations Lab. And in the second part, Diane and Olufemi will discuss the design of reparations, especially the issue of reparations for climate change. The Notre Dame Reparations Lab was created in 2019 with support of the Keough School of Global Affairs, in particular the Kellogg Institute for International Studies and the Klau Center for Civil and Human Rights, to combine approaches, quantitative and qualitative, approaches from political science and law, to study reparations for victims of human rights violations, the design of reparations, and the compliance by states with those reparations. So our lab has fundamentally four goals. The first one is to develop new methodologies to assess state compliance, and I will discuss this in a minute. The second goal is to collect systematic data on compliance with reparative orders issued by international bodies, like the Inter-American Court of Human Rights, the Inter-American Commission, and others. And we are excited that today we will release two data sets, two new data sets that will become public. The third goal is to evaluate the strategies to promote compliance. And I will show an example today of how we can use the methodologies of the lab to evaluate new strategies adopted by international organizations and by civil society to promote compliance with reparations. And finally, and this is going to be the central discussion in the second part of our presentation, to promote the design of novel measures to deal with complex reparations. So the first goal, as I mentioned before, was the issue of designing new methodologies to assess compliance, right? When we seek to analyze compliance, a central challenge for the analysis is always the issue of timing. So there is always this fundamental problem that it's not only whether states comply with a particular reparation, but it is also the issue of when they comply, right? Sometimes states may be unable to comply simply because they didn't have enough time to implement the measures, even if they have the political will to do so. Sometimes they may comply, but they may take a very, very long time, and that is really a problem for the victims that are waiting for the reparations. So we sought out to figure out a methodology to address issues of timing in compliance, but any attempt to quantify delays in compliance presents a fundamental methodological challenge. And this is because we can observe and quantify the time that states take to comply only in cases in which they choose to comply, right? But we cannot measure time to compliance if states have not complied yet. So this is a fundamental problem that we need to deal with. And let me give you a very simple example to get a sense of how this works. So imagine that we have a court, an international court, that orders two reparation measures, right? The first one is ordered in 2011 and the state complies in 2016, right? The second order is issued in 2015 and the state complies in 2018, right? And so essentially we observe two events of compliance here, right? In the first case, it takes 5 years to comply. In the second case, it takes only 3 years. But imagine that we are conducting an analysis of this problem in this hypothetical example in year 2016. And so we observe in this case only one event of compliance, right, that happened in 2015. And if we try to assess time to compliance based on the data we can observe, we conclude that, well, the state takes 5 years to comply. But of course, we are not observing the time to compliance in the second measure that still remains open. So we need to use this information in some way. The way we typically deal with this problem in studies of compliance is that we say, okay, the state has complied with 50% of the measures that it has been ordered to comply with. But of course, this is very poor information in a way, right? Because in this case, we are ignoring that the state took a long time to comply in the first case, and we are ignoring that the state didn't have any time to comply in the second case. So we need a better strategy, a better methodology to deal with this problem. And this is at the core of the work that the lab is doing. So to solve this problem, we look at the probability of compliance over time. We observe reparation measures on a yearly basis and estimate the probability of compliance per year. So in this example, we have one event of compliance and 7 yearly observations, right? So this gives us a yearly probability of compliance that is equivalent to 14%. So now we have a different metric that is based on a yearly calculation. And what is great about this strategy is that, first of all, it allows us to employ advanced statistical models and data science tools to estimate how the probability of compliance changes over time according to different circumstances. But also, and equally important, it allows us to retrieve an estimate of time to compliance that uses all the information available, including the information for those measures without compliance. So in this very simple example, if the inverse of that 14% is an expected time to compliance of 7 years, right? So the expected time to compliance is the metric we use to capture delays in compliance by states. And I will show you some examples of how we do this later. So this methodology allows us to evaluate the effectiveness of different instruments to promote compliance, as you will see. But Also, so that we can implement it, it requires us to collect data on compliance with orders of different institutions. And so for this reason, I am particularly pleased to announce that today we are going to release 2 new data sets on compliance that the Reparations Lab will make available to the public. And in order to do this, I would like to, in order to introduce those data sets, I would like to invite to participate 2 collaborators, 2 members of the lab who have worked very closely in the development of these data sets, Shay Smith and Mariana Broca. Shay?
Thank you for the introduction, Professor. My name is Shay Smith, and I am a senior here at the University of Notre Dame studying political science and global affairs with a concentration in civil and human rights. So I began working with the Notre Dame Reparations Design and Compliance Lab in the spring of 2020. So I've been working with the lab for almost 2 full years now in various capacities. But right now, the project that Professor introduced that we have been working on is on the Inter-American Court. And so this data set, which is now available at the link you see on the screen, contains information on individual reparation measures issued by the court to a specific state. So the data set is comprehensive and includes nearly 300 cases that have been published by the court since 1989 and is updated through 2020. So we have the current version of the data set, like I said, is through 2020, and we will continue to work on adding additional cases and supervisory resolutions as they are published through 2021 in order to have an updated version of the data set in the future. But what we currently have available is information on the cases, so the case name and the country, and then we are using this data set particularly, like Professor said, to assess compliance with reparation measures. So each of the individual reparation measures listed in the data set has information on the number of resolutions which have indicated compliance with the measures issued to them, the years in which they were complied with or there was pending compliance still. And so these dates allow us to measure partial compliance with the resolutions or the reparations and full compliance. So we have different measurements in the data set to allow us to see this progression of a case, how many years it takes for a case to reach full compliance and ultimately be archived by the court. But this is the current state of the data set, and we invite you to look into it. And all of us here at the lab who have participated in this project are very excited to have finally publish a version of this data set. And so we invite you to check out the link there on the screen and see the data set for yourself.
Thank you, Shay. Mariana?
Good afternoon to everyone. As Professor Perez-Linian said, my name is Mariana Broca, and I graduated from the LLM in International Human Rights Law at the Notre Dame Law School in 2020. And that's how I started with the Reparations Lab project on the Inter-American Commission on Human Rights Reparations. But before I start describing our work and the data set that we made, it is important to highlight that this was a collective work which included the collaboration of both students and researchers. And in this regard, Francesca Parente and Ana Shansi Orizaga's work was essential. So, as I mentioned, thanks to this project, we created a data set that covers all the cases for which the Inter-American Commission on Human Rights has published reports on the merits from 1992 to 2019. Hence, it should be noted that this universe of cases does not include those that have not been made public yet for obvious reasons, according to Articles 50 and 51 of the American Convention on Human Rights. And to create this data set, we used 2 primary sources. First, the fact sheets of the Inter-American Commission on Human Rights and that issues the Inter-American Commission, where it follows up the individual cases compliance, and second, CIMORE. Based on this, we analyzed all the merits reports that are available, and we included in our data set information such as the year of its publication, the year of the petition was filed, the year of the admissibility report, and the initial merits report that is different from the one that was published, the names of the victims, the petitioners, the year of the crime took place, the description of what took place, and the actors that committed the violation. These reports offered by mid-2021 an amount of 493 recommendations. So we analyzed and classified each of them according to the type of measures that were asked to the state. And we distinguished if there was full compliance, partial compliance, or no compliance. And in those cases that we found that there was full or partial compliance, we included the year in which that happened. So this information allowed us to observe the recommendations on a yearly basis, as Professor said, starting on the year when the Commission issued the initial report under Article 50 of the American Convention until compliance took place. But we also determined the existence of compliance agreements between the parties, meaning the state and the petitioners, and the year they took place. Basically, compliance agreements are a means of settlement within the individual petition system that the parties can pursue after the Inter-American Commission has issued its merits report to specify its recommendations, which are generally are commonly established in general terms, and define their ways and dates of compliance. So this is very important because they are generally misunderstood as friendly settlements, but they have very important differences, such as the compliance agreements do not have a legal basis. And this finding is very significant as there is a lack of information on this topic. And Professor Perez-Liñán is going to continue talking a little bit more about this.
Thank you, Mariana. This, in a way, this issue of compliance agreements leads to the third goal of the lab, which is the evaluation of mechanisms that promote compliance. And I think the example of compliance agreements in the case of the Inter-American Commission on Human Rights is an excellent example, right? As Mariana was pointing out, compliance agreements are signed by the states and representatives of the victims after the Inter-American Commission on Human Rights has issued a report on the case, or reports on the merits of the case, and they started as an innovative way of trying to find ways of implementing the recommendations of the Commission. But up to very recently, there was no literature on the topic, and it wasn't clear whether they were an effective tool to promote compliance. So we collected information. We collected this information that Mariana described in this data set, and the data sets, the two data sets are available in our website, as you saw. And we conducted an analysis of a statistical analysis using the methodology I described before to analyze the effectiveness of those compliance agreements in terms of reducing their ability to reduce time to compliance. And so we estimated the expected time to compliance for recommendations of the Inter-American Commission on Human Rights that in reports that involved compliance agreements and those that didn't. And what we found was that in cases in which there are no compliance agreements, right, the time to compliance is relatively long if you estimate the probability and then translate that into years. But when there is a compliance agreement, the time to compliance effectively is cut in half. So this is evidence for the effectiveness of this instrument that up to now was virtually there was very little study about it. Because we are estimating statistical models that are involve multiple variables, we can control, for example, for the nature of the nature of the recommendation, the type of recommendation, beyond whether there is a compliance agreement or not, right? And we can see that if we analyze different types of recommendations, right? Those compliance agreements seem to have effects, even if we disaggregate the type of recommendation that the Commission is making. But they have similar effects in multiple cases, right, where this restoration or measures of non-repetition, for example. But what is most interesting is that they have even a more visible effect in the case of measures of truth and justice, which often imply the investigation of serious crimes and the prosecution of perpetrators in the security forces, that, as we know, it's something very difficult for states to do. So compliance agreements, of course, you can see that the time to compliance in this case, the probability of compliance is so low that the time to compliance, especially when there is no agreement, is extremely long if we translate that into years. But compliance agreements, even in this case, seem to be very effective in promoting compliance. So this is an example of how the methodology of the lab can play a role in helping us analyze compliance and the effectiveness of new instruments. Finally, the fourth goal of the lab, in addition to developing new methodologies, in addition to collecting data and make the data sets public, in addition to analyze empirically the effectiveness of compliance instruments, the fourth goal is to think about and analyze the design of reparation measures, particularly in very difficult subjects. And on this topic, I have the pleasure of inviting Diane again to talk us about that. Diane?
Thank you very much, Anibal. It might seem counterintuitive for international lawyers who think about the design of reparations for human rights violations to think about it by means of backward induction, looking at it from the standpoint of why do we look to how states comply and why they don't comply. If we take a look at where we are today in terms of what is required under international law for reparations design, most of the time we rely on what victims themselves would ask for, and then what the respondent state would say, and then ultimately what the court would adjudicate based on the universe of what a plaintiff asks for, what a respondent says it's capable or incapable of providing, and what the court says the law is on the subject matter. But that in and of itself is also a challenging form of linear analysis that does not reach the measure of actual justice in many circumstances. And this is why I'm so excited that we have Professor Taiwo discussing with us today, because he's going to talk to us about what that real justice is. So for now, for my part, let me talk for the next few minutes on where we are in the structure of reparations design in international law and human rights, and why in particular, in the context of the work of the Reparations Lab, it was so crucial on my end to collaborate with Professor Perez-Liñán and many of our students who are in the lab to do that backwards induction of finding out exactly not just the expected time to compliance, but the nature of the kinds of measures that courts as well as other tribunals order to ascertain what in general is effective from the standpoint of the human right that has been violated, from the standpoint of the victim that's seeking justice, and also from the standpoint of the institutional legitimacy of the court or the tribunal that is in the process or is in the task or mandate of trying to render justice. So turning to reparations design in international law and human rights, what you will find quite commonly in the international system is, let me just turn this. What we will find most commonly is that most tribunals will impose this one standard. The standard that is applied in international law all throughout as to what is the standard of reparation anytime there is a breach of international law, including human rights law. And the standard was defined in a case in 1929 that was determined or decided by the Permanent Court of International Justice, the predecessor court of the International Court of Justice at The Hague. The standard says that when there is an illegal act the reparation must do two things. First, it must, as far as possible, wipe out all the consequences of that illegal act. And second, try to reestablish the situation that would, in all probability, have existed if that illegal act had not been committed. So the very legal standard itself calls for judicial imagination. And the unfortunate thing about lawyers who are constrained to follow how plaintiffs craft what it is that they think will render justice in their claims is that to a certain extent, courts may end up finding themselves institutionally hamstrung by the limits of their own jurisdiction and what they can order and what they think is consistent with addressing the harm that was caused from the breach of the international law rule or the human rights rule. That in many circumstances, what we find is that courts and tribunals default to a system. Instead of applying this two-tiered, two-pronged system, courts often default to a typology-based analysis of reparations. Here, I refer to the forms of reparation for state responsibility that were codified by the United Nations International Law Commission in their 2001 draft articles on the responsibility of states for internationally wrongful acts. This is the same typology that is used by the International Court of Justice, that is used by international economic tribunals, that is used by law of the sea tribunals. Virtually all tribunals that try to think about reparations for state responsibility will follow this typology. Why a typology? Frankly, this was an arbitrary assignment by the International Law Commission's drafters of these articles that didn't have the empirical training that was attuned to understanding issues of compliance. So they thought of first doing restitution in integrum, try to return a thing that was lost. And if you can't return it, try to pay for it with compensation. And if you can't pay for it, try to apologize for it. That's satisfaction. But as we know from human rights violations, from the standpoint of human rights victims, from the standpoint of those who suffer the harms from breach of international law, reparations are complex. They are not so easily categorized into the return of a thing, payment for a thing, or apologies for a thing. So clearly something else has to be done. And this is where, unfortunately, in the international system, the continuing reliance on translating what was initially a very broad standard, a two-pronged standard of understanding how to wipe out all the consequences of an illegal act, and thereafter trying to reestablish the situation closest to a situation before that illegal act was committed, that has now been canalized into this type of reasoning. And this has resulted in a very uneven practice at international courts and tribunals. A very recent case at the International Court of Justice is a case that involved the Democratic Republic of Congo versus Rwanda, involving a series of human rights violations and humanitarian law violations, which 15 years ago, the court said that the DRC was responsible, but that Rwanda had to negotiate with the DRC. But because there was no monitoring on the part of the International Court of Justice, there was certainly no consideration for what Professor Perez-Liñán was talking about, the time to compliance, even with an order to negotiate. The court found itself 15 years later with no reparation in sight, that it had to build proceedings or initiate proceedings all over again to do what it was supposed to do at the outset, which was to design the reparation that was due for all the declarations of breach of international human rights law that it had made 15 years earlier. Fast track to 2021, we're nearly to 2022, there's still no reparations in sight. And that is precisely the quandary that we have if courts rely simply on the typology of restitution, compensation, or satisfaction. Clearly, there is a mismatch between understanding what is sought to be repaired and how to go about doing it in a manner that truly achieves justice for the parties. So we see the same kind of uneven practices in specialized international economic tribunals, in the regional human rights courts that all have different forms of mandates and powers within which they can order things to be done. And we see a very narrow space in international criminal tribunals. There's a victims fund, for example, at the International Criminal Court, but to the extent that they permit reparation, it is of the symbolic compensation kind. So say for crimes against humanity, in a recent case in Lubanga, the court orders symbolic compensation of $250. Why does that make sense? As opposed to, say, an investor-state arbitration, where for injury to property, the investor can receive not just 100% of damage, but potentially more based on anticipated lost profits. So there's a dissonance between how courts and tribunals do this. And our intuition at the lab is that to a certain extent, this is because courts and tribunals have not been as mindful about the conditions that may prevent, deter, or otherwise undermine the ability of states to comply. So if that is the case, and this is the conundrum, where from our standpoint do we think that reparations design, in having this conversation about reparations design, compliance is the first step. The next step in what we are looking at and what we're interested in continuing the work of the lab is looking at the design criteria based on our own review and our close, very granular study already of cases, as well as looking at the empirical findings with compliance. We posit that there are 3 criteria that ought to be considered by courts when they're designing bespoke reparations. One is the actual responsiveness of the intended reparation, contemplated reparation, to the harm that is caused by the breach of international law. And here we reinforce the notion that there should be intertwined analysis of both not just the situation of the victim of the breach at the time that they're asking for reparation, but also the separate recommendation to return to the situation before breach, to proactively think of measures that will return the victim to the situation before breach. The second is also an issue of determining appropriateness, because again, international courts and tribunals, we operate in a space where we don't have a blank slate. We now have existing courts, existing processes, and to the extent that existing institutions have jurisdiction, there are limitations within that jurisdiction and within those powers and competences vested in these international courts or tribunals that may also constrain how they monitor, how they design, how they supervise whether or not a state complies with a reparative order or judgment under international law. And thirdly, one of the things that we've also taken a look at draws also from the very same jurisprudence of the International Court of Justice, and this also goes into my own work and my own research on reparations in international law as well as in human rights law. In jurisprudence, we take into account equitable considerations between the injured party and the injuring party, a fact that was recognized by the International Law Commission, because we try to avoid a situation of punitive reparations that themselves could also breach international law in their consequences. So one example, or the example that is most feared by everybody, is a return to a Versailles Treaty type of reparations arrangement, where you could basically cause a state to be in debt, but also from a moral standpoint, cause subsequent generations to feel aggrieved at having to basically pay for the sins of their fathers, right? And to the extent that that also has to be considered in designing the reparation, in designing reparations that are not just backward looking, but also forward looking, our next phase of research based on our initial standpoint of determining those initial conditions for what gets us to state compliance, our next line of research focuses on these 3 criteria. So on this point, let me stop here because I want to turn to a classic, for me, the best possible example of how complex it is to do reparations in the international system. And we are pleased to have Professor Olufemi Taiwo, who is an expert and reconsidering reparations in particular, who has his book coming out. And I love that he's a philosopher, because we're going to go straight into the heart of what does it mean to do justice? And especially in a case involving climate, where you have many countries, many actors who contributed to the harm in various degrees. And then you have other actors who may not have contributed to the harms, but they're also suffering the most harm, as in the case of, say, small low-lying islands that are most affected by the potential or actually imminent loss of their homes due to sea level rise from climate change. I would be interested, and rest of us in the lab are very interested in engaging Professor Taiwo, especially on his thoughts, because the dimension that we, at least I intuitively think we're missing here is how close do we get to redressing the harm? And what kind of thinking do we bring into it for purposes of understanding, or at least trying to educate courts and tribunals about how to begin that conversation about redressing harm? And on this note, let me turn over to Professor Taiwo. Good evening.
Good evening. Thanks so much for having me here. I'm really excited about the work that you all just summarized. I think it's really invaluable stuff politically at the moment we're at, to have a kind of serious investigation of what it actually takes in practical terms to move the institutions that we have, which are states or multinational institutions, in the direction of the kind of justice that we're trying to pursue by way of reparations. And so I'm really looking forward to reading the report that you all have released and trying to think through these practical questions with you all. But what I work on in the space of reparations is reparations for transatlantic slavery and colonialism. And one of the things that I'm struck by, both in the process of making the book and in listening to the report just now, are both the ways in which this kind of reparations, this kind of topic under the heading of reparations, really shares a lot of the conceptual intricacies of reparations more generally, but also has its own kind of unique challenges and complexities that allow us both to learn from other reparations contexts, but also to challenge ourselves to think, what is this particular kind of reparations demand, and what can we learn about other kinds of reparations from this reparations idea, and vice versa. So what I would like to talk about are the two main contentions of this view of reparations that I have, and that Reconsidering Reparations, the book, is about. So the first claim is that reparations is world making, that we're talking about politics of a planetary scope, and that conviction about reparations means, practically speaking, that in the 21st century, when we're facing a world-making crisis in the climate crisis, that reparations for transatlantic slavery and colonialism should take the form of the pursuit of climate justice. So a kind of look backwards to look forward. The way that I understand the last 5 centuries or so of history, beginning with the Portuguese and Spanish Empire, beginning what would be transatlantic slavery and colonialism in the Gulf of Guinea in the mid-15th century, is we have a global social structure now. That is new, historically speaking. It is not the case that in all of human history, there has been a planet-sized system of economics or politics. That is the result of quite historically recent trends in the way that human beings were living, trading, and doing politics with one another. The historical forces that built that planet-sized system were transatlantic slavery and colonialism. And partially because of that, and partially because of developments since those things, the planet-sized system that we have is a distributive system that has the following features. Social advantages accumulate in global north and in the racially dominant communities, white communities. That second bullet point should say disadvantages. Social disadvantages accumulate in the global south and in racially disadvantaged communities. And this is something that holds both within and across political communities. So for the most part, show me a country, and I will show you a country in which the most racially dominated have the worst outcomes with respect to public health, with respect to access to wealth, with respect to access to political power, and show me a region, and I will show you a largely racially distributed set of different levels of state power, right? So planetarily speaking, the US and Western Europe hold a disproportionate share of political power, both institutionally and in terms of wealth. All of this is a way of saying that racial injustice is itself distributive. We can think about security with respect to housing or energy or environmental security. We can think about political power, resources, money. But all this is a way of grouping what would otherwise be different headings of racial justice and injustice. But changing these distributions is what the project of racial justice is, as I understand it. So if our distribution system is planetary in size, in scale, and scope, then the proper task of reparations for transatlantic slavery and colonialism is no smaller. It is to rebuild the world, literally speaking. And that is something that separates reparations for transatlantic slavery and colonialism from reparations writ large. That's not to say that the arguments that I'm going to go on to make only apply to this kind of reparations, but it's to say that they don't necessarily apply to any conceivable case of reparations. So when I put this PowerPoint together, I had, of course, not heard Professor Desierto's presentation, and I was very struck by the slide talking about the legal standards for reparations, the first two being restitution in integrum, giving people the thing back that was taken. The second being compensation, if the thing can't be returned, maybe something of equivalent or nearby value. And the third being satisfaction, an apology in lieu of the first two. And that is eerily similar to the three kinds of arguments that you see for reparations for transatlantic slavery and colonialism. And I think the difficulties of that position in international law generally are inherited in the reparations arguments for transatlantic slavery and colonialism. Sometimes you see people making harm repair arguments, saying that reparations for transatlantic slavery and colonialism should be justified on the model of restitution and the return to status quo ante. But if you really stare at this from a philosophical perspective, it's a little difficult to conceptually make the case that there's a meaningful sense of status quo ante. Wars of native elimination, the enslavement on a mass scale of millions of Africans are the conditions of possibility, not only for the levels of wealth of the states that exist today, but actually the existence of those states in the first instance. There is no United States in the absence of wars of native elimination against the indigenous population of the United States, the inter-imperial transitions of land between French, Spanish, and Dutch empires and the British Empire and then the United States. And of course, the wealth disparities between the US and global South countries like Africa are themselves co-produced by those very same processes. So status quo ante, the level of welfare that people would have if it weren't for these processes doesn't seem to have a meaningful counterfactual there. So it's very difficult to make the kinds of arguments that tort law and injury law are predicated upon making, the kinds of counterfactual comparisons between this world and the world but for the breach, but for the injury. As a result of that, I've turned towards the kind of view that is on the screen here that I call the constructive view. And that's the view that I've taken from the many decades and centuries of Black and Indigenous activists for reparations, who seem to have thought of it as a political project to create tomorrow's just world and justly distribute the costs of that creation rather than an urge for restitution in light of yesterday's injustice. So we're trying to build something in the future, not recover something from the past. The ethos of this view is construction rather than repair, distributive rather than retributive justice. And as I just mentioned, we look forward when we talk about the kind of world that we want to build, and we look backwards when we try to decide who has to be on the hook for building it and to what extent. Some people challenge me on this view. They're like, to what extent is this even a reparations view? Reparations views are inherently backward looking, right? You're responding to injury in the past. That's what makes a view a reparations view. This distributive stuff that I'm talking about, this constructive stuff that I'm talking about, it's forward looking. It's trying to build a new world in the future. But I think this division is artificial. What social structure is an accumulated result of social processes. It is the combined weight of all of the times that I've saved money that decides what number is in my bank account, for instance, right? So when we're intervening, when we're creating future worlds, we are creating new accumulations of what we've inherited from the past. We are redistributing what we've inherited from the past. So future creation is backward looking functionally. It does change our relationship to the weight of the past. It just doesn't change what happened in the past and doesn't aim to change what happened in the past. So that's the difference from the kind of restitution way of thinking about reparations that the constructive view is built to carry forward. The thing we should be distributing are capabilities, so capacities to achieve functionings. This is something that I'm taking from Amartya Sen. I'm happy to talk a bit more about it. I'm going to move through quickly just in the interest of time, but essentially, the ability to access food is a capability. So rather than distributing bags of rice, we could think about making it possible for people to come by food in a variety of ways. That means that what we should be distributing aren't necessarily resources in the orthodox way of thinking about resources, not necessarily income, not necessarily wealth, or not just those things, but the ability to live life in a certain way. That might mean distributing things in the world itself rather than dollars in people's bank accounts. You might distribute fruit trees so that people can access food rather than just distributing dollars. And some of those affordances, things that we can use practically to move throughout the world, are directly related to governance. So redistributing political power, redistributing political institutions that make them more usable by different amounts of people. And by people of different levels of power and who are Black and Indigenous. All of this is to say that we should think quite holistically about the kinds of design decisions that we have to make in confronting the climate crisis. If the school is affordable but burned to the ground or underwater or only accessible through walking through a heat wave, that's not the just world we're trying to build. I'm going to skip this and talk about the design perspective, and I think a broad affinity between the thought of the lab and the at least the way that I'm thinking about this. So if what we're trying to do is give people the opportunity to determine their own lives, the capability to determine their own lives, and if how we do that is by changing what the world is literally like and not necessarily just the resources that people have, but the actual parts of the world where the trees are, what the institutions are, then these are design objectives. What we're talking about are refashioning the institutions that people confront and not just the resources that they have within those institutions or underneath those institutions. We're talking about building ramps rather than just recognizing people's rights. Ideally, we're talking about changing the built environment, both in the sense of our social institutions, our political institutions, and our literal built environment, actually building ramps. And I'm just going to give a few examples of the kinds of things that fit into that project. That would mean changing our information ecosystems, the kinds of institutions that build and distribute knowledge. Examples of that are citizen science, participatory action research, and other forms of community control over how knowledge is produced. For example, the indigenous folks who run the Nunavik Research Center, who are broadly in community control of the scientists who produce usable and wanted and trusted knowledge, for the people who, for the indigenous groups that run the center. We can think about constructing trees and green spaces, right? But we're not in the realm of apologies, and we're not even necessarily just in the realm of compensation as kind of ordinarily construed, as just sending checks. So just distribution of climate responsive actions and responsibilities would redistribute the burdens and benefits of climate policy, shifting benefits towards Black and Indigenous communities and the Global South, and shifting burdens more towards white communities in the Global North, and of course, affluent communities and less affluent communities in both of these cases. And I'll end by saying that there are a number of ways that you can do this. So when people think of reparations for transatlantic slavery and colonialism, they think of people getting checks. It's an excellent way to redistribute money and power. We should start there. There are a number of good ways of thinking about how to do that, whether it is giving African-American descendants of slavery bonds, for example, or giving a universal basic income with an increased amount for African-American descendants of slavery. These are two good approaches worth thinking about. But you also need to refigure who has power to distribute things in the first place, and not just redistributing money, but also redistributing power. And so on that point, I'm really interested in the idea of community control over how laws are made, over how science is made, over who controls utilities. Maybe it should be communities rather than investors. But all of these kinds of design decisions are the space of what I think of as reparations. And they're in the space of this broad goal of world making. So I'm going to stop there in the interest of time, but looking forward to hearing from everyone.
Thank you very much for that very thought-provoking discussion. I think we've got time for Q&A. And so let me turn to Professor Perez-Liñán, who will lead us off. I know there have been a number of questions in the queue. Professor Perez-Liñán.
Thank you, Diane. I'm sure you have many questions as I do. This has been a fantastic conversation. We have a few questions from the audience, and some of them are very interesting. The first question that we received is a rather technical one. And the question is, if victims of human rights violations get a favorable reparations judgment, can the victims sell the judgment to another state? Can the victims fight from the nation state property to get remedy?
And do
It belongs to you more than anybody else.
I think this happens a lot in international economic decisions, particularly in the investment space, where we have seen a proliferation of third-party funders who take an economic interest in awards that have already been proven before these tribunals, and then they try to enforce the award. But as a matter of principle, there is no clear process under which human rights judgments, or say judgments of the International Court of Justice, are necessarily have market portability. The right to enforce, or the right to seek enforcement of a judgment in international law, generally pertains to the victor, or the one who has earned that right pursuant to a decision by a tribunal. So I would say that this is a situation where we would have to finesse it as between jurisdictions. This is one of those appropriateness questions, as between the type of tribunal and whether or not that would even be permitted under current rules of international law. Some people have argued, and some scholars have argued, that there is an international human rights law dimension towards permitting the market transfer, towards the, allowing market transfers of cases that are imbued with public interest, as in the case of investor state arbitral awards. So those have been, that's a bit more technical, but I think I'll leave it at that point so that we could refer to other questions. Unless there's another question, Anibal, I'd like to follow up if possible, because I'm fascinated with what Professor Taiwo just discussed. And it's interesting because the prevailing legal standard we all operate with is Chorzów. It is a harm repair model. It's not a world-making model. Courts are afraid of being accused of being a political organ, right? And so to the extent that they want to stick to the confines of their authority, they want to stick to resolving a dispute that is before them, and they do not want to appropriate, say, the prerogatives of parliaments or the prerogatives of executive branches. They will often try to punt the question. And this is why you've got an International Court of Justice case in DRC versus Rwanda, where the court says, just negotiate between you. You have more or less, here are the violations, negotiate between you and how you're going to undertake reparations. But this does make me think, because why is it and how did we get to the point of adopting the Chorzów standard? And ironically, the Chorzów standard was a property case. It was the destruction of property in a time of war. Why is this the prevailing standard for purposes of redressing harm and providing appropriate reparations for harm? And so is it not, especially in the case of climate justice, where we have small low-lying islands such as Tuvalu and Barbuda, who have just constituted a commission to explore the possible liabilities of the global north in regard to climate change? Is this not also within the sphere of courts to think about the distributive consequences of their decisions, especially when the breach of international law itself creates those distributive decisions? And maybe to the extent that I find this new and novel, it flies in the face of the tendency under law to think in terms of the typology and to think solely in terms of the jurisdictional limitation that a court or a tribunal sees for itself. I mean, turning to Anibal, one of the things I find fascinating with the Inter-American Court of Human Rights is how from one provision, Article 26 of the American Convention, the court managed to extrapolate, here are all the economic, social, cultural rights that were not textually specified in the convention, but they evolved it over time. And just recently, they declared the right to a healthy environment. They declared the existence long before the Human Rights Council at the UN declared that there is a human right to a healthy environment. The Inter-American Court led the way before everybody else. And yet they're doing that without a clear textual hook, but from a sense of its own jurisdiction. So I'd be interested to see where you think this kind of analysis of reparations goes, especially since the court is one of the very few that actually has an institutional mechanism for supervising the compliance by states with its own judgments. So long-winded question, but Anibal, but let me punt that to you.
I think there is a part of the question for me maybe, and perhaps for Mariana as well, but also part of the question for Professor Taiwo. Olufemi, would you like to?
I can say something quickly. I think the point Professor Desierto made about the fact that courts are trying to avoid usurping the role that they might feel is properly left to legislatures seems like the right read of things if I were to guess, right? Because if the better way of thinking about reparations, or at least the more apt way of thinking about reparations in some cases, is this more constructive, design-based world-making approach, then the kinds of politically salient decisions about which responses to a bad history are the ones worth pursuing, I think really are in many cases properly the role of the legislature, at least as we've divvied up powers in the states that we have. And we could talk about much more thorough changes to how governance works, but in the absence of that seems like the right read of things. But the court does have, in at least some cases, you all would know better than me whether or not this applies to reparations law, but the court can issue injunctions, right? They can order entities to stop doing something or to start doing something. And you could imagine forward-looking uses of injunctive relief as a kind of response to the kinds of problems that climate crisis is going to involve. So whether, international courts could order, here's a question for the legal experts in the room. Couldn't international courts order a country or a consortium of countries to relocate people who are displaced, and to do so in a way that meets particular criteria of loss and damage, and that is at least inspired by the kinds of thoughts that usually go under the heading of restitution, right? What is it that people have lost in terms of their life ways, and not just the monetary value of a house, right? It doesn't seem to me like that's something courts couldn't do. And if they could do it, maybe they should.
Let me briefly reply to that and then turn to Anibal. The Human Rights Committee of the UN, which is not a court, it is a treaty body that supervises the implementation of the International Covenant on Civil and Political Rights, actually dealt with the question of, in particular, what do you do with climate refugees? So there was a case that was brought by a climate refugee who says, I've basically lost my life. I'm from Kiribati, and because my state refuses to perform its climate commitments, this is what has ensued. And because other states have failed to fulfill their climate commitments, ultimately all the structural conditions are ripe for purposes of me losing my world, so to speak. And that, I think, is something that I find interesting, because while the Human Rights Committee says we're not a court, we're not vested with the resources of a court, but we acknowledge how the structural decisions and the non-compliance by states with their climate commitments could cause this kind of harm and damage. And so to the extent that they can issue recommendations to states that, yes, you should be doing things better, they do that. And they did that in that particular case. Contrast that, for example, with the Hague District Court. This year, May 2021, the Hague District Court, a local court at the Netherlands, issued a decision requiring Royal Dutch Shell to slash emissions by 45%. Automatically across the board. That's also a design question, because I think of it in pretty much the same way. If courts were cognizant of how they are intrinsic to the dialogue of setting up the conditions for states to comply, then we wouldn't have to wait for legislatures to act. I mean, I worry about that, because if we waited for legislators to act, Brown v. Board of Education would never have materialized. We would have waited forever for legislatures to declare that something as grossly immoral as racial segregation was actually antithetical to the Constitution. So my question to Professor Perez-Lisñán is, how then are we supposed to take a look at these decision makers who have an authority to adjudicate reparations, maybe not in the sense that we understand them in any particular type of measure, but how should, based on your own analysis of the Inter-American Court's own unique jurisprudence, how do you think courts could be involved in this conversation on designing reparations?
So I think, Diane, that this is a critical issue, and I think Mariana knows the jurisprudence of the court much better than I do, and so she may want to say something about this. But my sense is that the Inter-American Court in particular has established very clearly that for them, the American Convention on Human Rights is a living document, right? And so that means that in practice, over time, many of the classical issues in Latin America of gross human rights violations, even though they continue to be important at some level, have become less important in a context of democratization. And therefore, the issues that have become increasingly important for the court often are issues of economic, social, and cultural rights. And what that means is that besides these classic categories of reparation, of restitution, compensation, and satisfaction, measures of non-repetition, structural measures, have become increasingly important for the court, right? And this creates a whole set of tensions and new complexities, both in terms of design. Sometimes it's very hard for a court that is detached from the domestic context to design very detailed measures of non-repetition, structural measures, but also in terms of monitoring, right? Monitoring these measures, to the extent that they are by definition broader and more ambitious, compliance is much harder to monitor for the court. So this creates a new series of challenges. And going back to Olufemi's point, which I think it's fundamental, right? This category of non-repetition often involves measures that are redistributive in nature. So I suspect that some of our most important challenges will be there in the future. I don't know, Mariana, if you would like to add something.
Yes, sure, thank you. Yes, I was thinking when you were talking about the jurisprudence of the Inter-American Court on Human Rights, and particularly how, since the advisory opinion, the number 23 that recognizes the environmental rights, the Inter-American Court has developed this standard regarding these rights, and particularly economic, social, and cultural, and also environmental rights. And I was thinking about a case against my country, Argentina, with La Cajonat, that recognized the violation that the state has perpetrated against indigenous people, and how the guarantees of non-repetition were essential as a part of the reparations. And also now there is a new case, Vera Rojas against Chile, that also recognizes expressly the principle of non-regression, that this is very important because it's essentially is critical for the recognition of these rights. And that's what I wanted to add. Thank you.
We have two questions from the audience, and I really appreciate the audience that is following us today. And I think we have two questions that point in the same direction and are worth addressing. The two questions, the two questions in a way address the same point. One is a question by Doug Cassell, and I'm really pleased that he's with us today. And the general point of the question, both questions refer to the empirical analysis that we presented earlier about the effectiveness of compliance agreements, right? And what Doug Cassell is pointing out is that maybe the states that are more respectful of human rights or which are under more domestic or international pressure to comply are more readily willing to agree to reparations and therefore sign agreements, right? And somebody else in the audience asked a similar question, which is, it's framed in a more technical way, but it's very similar, which is, are you worried about selection effects? Meaning that compliance agreements are signed in a non-random subset of cases, and it could be that states that sign compliance agreements are more inclined to compliance anyway, and so there is this omitted variable, the willingness to comply, that really drives the differences, not the agreement themselves. So I think the two questions point in the same direction, right? The probability that, the possibility that states who are willing to sign compliance agreements to begin with they sign the agreements because they are already willing to comply. And I would add an additional complication to the analysis that there is a potential confounding factor, which is the idea that this compliance agreement started around 2003, as far as we could tell in the investigation with Mariana. And the world was not the same before and after this period, right? So there is a very interesting study by Francesca Parente that shows that around 2001, there are reforms in the Inter-American Commission, in the procedures of the Inter-American Commission. And by clarifying the procedures, the Inter-American Commission makes the default practice to send cases without compliance to the Inter-American Court. So before 2001, the fact that cases without compliance would be referred to Inter-American Court was less likely. After 2001, it becomes more likely, right? So it's not only that some states may be more willing to comply and therefore more willing to sign agreements, it's also that the timing in which those agreements take place after 2003, it's a different historical period than the period before in institutional terms. And so I don't have a perfect answer for that because, of course, determining causality is always the most difficult problem we confront. But the analytical solution for this, and again, this is a kind of a technical answer, but the analytical solution that we found for this in our report is that we conducted a second analysis, which is a difference in differences analysis, which essentially means that we are controlling in our analysis for the period that is before and after 2003. And we are also controlling for the fact that some reports on the merits are eventually subject to an agreement and others are not, right? So there is going to be this selection effect that we don't know exactly why, but some reports on the merits, even some reports in the corresponding to the same state may face an agreement or maybe benefit from an agreement and others do not. So we control for these two factors when we are conducting the analysis in order to remove the unobserved mechanisms that expose some reports on the merits to agreements and others not, and to remove the effects of the historical period. So technically, we're estimating in this second analysis the treatment effect of agreement on the treated cases. And we still find that the effects are equally significant. So we are pretty confident that there may be some selection agreements going on for sure, but even when we try to account for those selection agreements, the effects of compliance agreements seem to be quite significant.
If I may, at this point, I'm glad Mariana brought out La Cajonat versus Argentina, because it's also one of those fascinating developments involving environmental law and human rights. To start taking a look where we are now, at least in the law, is to start taking a look more at the duty to prevent, not just the duty to redress, but the duty to prevent, and what a state's duties are to prevent foreseeable damage, foreseeable climate responsibility in this circumstance. And this brings me back even more to the thinking of world making, right? So to the extent that we think of in law, if the framework is, if states, especially in these far-ranging decisions of the Inter-American Court, states have a proactive duty to prevent environmental harm. That, because of science, we now know is more foreseeable in a very anthropocenic century that we live in, where we know human activity is the biggest driver of climate change. To the extent that Professor Taiwo was talking about the distributive consequences, don't these also run hand in hand with a state that should also be anticipating what its duty to prevent is? And so maybe to the extent, maybe I'm starting to wonder whether or not the next phase of where we're looking at in climate reparations, because, you know, we've got a multitude of cases that are pending all throughout the world. There's one in the Philippines, the carbon majors case. There's Hague cases. There's cases in Canada that are not specific to climate change, but generally on environment, that continually try to push the boundaries of what is that duty on the part of states to prevent environmental harm, especially something on a planetary level. If we're moving beyond the very individualized allocation or responsibility for harm to more of a, almost like a negligence model, you failed to look at the conditions or tried to build the conditions in what Professor Taiwo was talking about, world making in this respect, which has that analog if we look at the duty to prevent. Where do we think the examination of compliance and conditions for compliance will come in for these kinds of complex reparations? I mean, I just get fascinated because the Inter-American Court pronounces extensively on these proactive duties. And it's not something you can pay for. It's not something you can return or not something you can apologize for. How do you repair when there has been a breach in regard to a duty to prevent? And I'll address it to everybody in this webinar, because I do think this is something worth ruminating on, especially when we start looking at interlocking issues, whether it's racial injustice, whether it's colonization, or the current inherited structures that we have in regard to resource distribution and extraction that has largely precipitated and driven climate change. And I get fascinated because out of all the courts, it's the Inter-American Court that's taking the more and more progressive stance, but at the same time, it's also a counterpart challenge for how to identify and how to design reparations going forward. If based on our findings at the lab, if it takes so much longer to say design reparations where the state's required to do something like investigate a perpetrator or pass a law, does this militate in favor of weakening the possibility of reparations in the adjudicated sphere, in which case it becomes less relevant? Institutions and courts, in this instance, becomes less relevant for purposes of realizing reparations.
I think one of the issues, Diane, is that these orders to repair damage are doing multiple things at once, right? And one of them is related to the broader idea of restitution or compensation. That is the idea that there can be some attempt to provide provide some compensation to the victims of the damage. But at the same time, I think there is a broader aspect that has to do with the impact beyond compliance. And this has to do with the change in the standards under which the states operate. And I think it's this change in standards that is the one that it's less unilateral in the sense that it emerges from a dialogue between the states and the court and the states among themselves over time, right? And so this is much harder to track and to determine. But probably this change in standards what produces the most important effect over the long run.
I wonder, I'm just thinking back to the ruling against Shell, where what the court demanded, I suppose, is I guess in a sense for Shell to do something, but maybe another sense for Shell to stop doing something or do something less, less quickly, which is polluting the atmosphere, right? And the demand, if I recall correctly, came with a deadline. And I suspect if the courts have a role in the world-making view of reparations, that kind of ruling might be central to it, where rather than coming up with, this is maybe in tension with something I said earlier about injunctive relief, but maybe rather than pressing corporations and bad actors and states to come up with the remedies and to negotiate amongst themselves in the way that maybe failed in the case of DRC versus Rwanda. Maybe what the courts can do, what the courts can offer is taking a ready-made target that isn't world making, right? Just lowering emissions isn't world making, but it is a necessary condition for any kind of world that we would want to live in, right? That the pace of emissions slows a bit. So maybe just taking an aspect of what needs to happen to build a different kind of world and relying on a broader kind of progressive ecology, whether activism, whether legislators, whether executive action, to kind of fill in the gaps.
So we're drawing to a close and we have about 5 minutes before we have to finish this webinar, but I do appreciate the insights that have been brought in, both empirical and philosophical, and probably want to stretch this out a little bit further, especially since the reparations lab is in the next phase now that data sets have been launched and the research, the information for streams of research are there already, courtesy of the data sets that have been publicly available. Perhaps one of the things I'm thinking of, especially in regard to climate action cases, is that more and more we're seeing a deviation from standardized reparations that plaintiffs are asking for in climate cases. In many of these climate cases, filed before national courts, plaintiffs are asking not just for governments to follow their nationally determined contributions. Sometimes they even question whether or not those nationally determined contributions are enough and whether they have gone farther than what is required for purposes of envisioning climate justice. But I see that already, and this is why I was very fascinated with looking at the distributive consequences, because I see that the wave of litigation is already there. And so to the extent that courts inevitably will have to deal with climate reparations one way or the other, because we've got multiple litigations taking place around the world before different national courts. I'm wondering whether it's problematic for many courts not to undertake their own kind of supervision in the way that the Inter-American Court has been proactive about anticipating the supervision that's required. I mean, the International Court of Justice has no supervisory unit, unlike the Inter-American Court of Human Rights. National courts, depends on which jurisdiction has the resources to do this kind of supervision of compliance going forward, especially since it might be helpful for purposes of a court to know whether or not the way that it's designing reparations is something that's part of a process, an ongoing dialogue, as Professor Taiwo was talking about, and as Professor Perez-Liñán was talking about in regard to developing standards on what that ongoing dialogue should be. So I guess my question, punting this back to Professor Perez-Liñán on the Inter-American Court is, and possibly also to Professor Taiwo, should we more proactively be thinking already not just of the substance of reparations, but how institutionally we should be having the monitoring of compliance with these reparations, and how do we do that in a way that's truly inclusive and truly does involve all stakeholders that ordinarily would be excluded from a private dispute between two parties. So please feel free to jump in.
No, I think I completely agree with you in the fundamental sense that the more ambitious and the more complex the reparation regimes become, the more important the process of supervision is going to become as well, and the more complex and the more challenging, and therefore, I think it's going to be increasingly important for courts to have important instruments of supervision, right? As you pointed out, the Inter-American Court has developed important mechanisms of supervision, but over time, the European Court of Human Rights has even though it preserves the original structure, right, has developed more technical instruments to support the work of the Committee of Ministers in terms of supervision. And so I think that inevitably, given the complexity of the topics we're discussing, the reparation regimes are going to become more demanding. And as a result of that, the problem of supervision is going to become more important.
I agree with that. And I would just add quickly that I think the political context of regulatory capture in a lot of places just pushes more in favor of the need for supervisory powers for courts, right? If especially in the case of regulating corporations, but even in the case of regulating states, if the sources of information are controlled in name or in fact by the people who are supposed to be providing the reparations, it's going to be very difficult to get short times to compliance and very difficult to get substantive compliance at all. And so I think courts having a way to kind of check the actors who are supposed to be providing reparations that is independent of them and controlled by the court, but participatory as far as the broader community goes, is going to be important politically.
So we may very well end up with what is inherently a political process to begin with. And so
Yes.
Possibly the sharp separation that courts might be insisting on actually might have to move or be nudged further into acknowledging its political space when we start looking at things such as supervision. We could definitely go on with this discussion, but we are at the top of the hour at the webinar over here. Let me extend my thanks first and foremost to Professor Perez-Liñán and to our lab representatives who are here, Shay Smith and Mariana Broca, who have tirelessly worked on building these public data sets, which are now part of global public goods. on the back of their hard work, looking into the work of the commission and the court, and we hope to collaborate further with more lines of research going forward on research design and reparations design. But most importantly, to Professor Taiwo, who wrote an extremely provocative piece that got us all thinking about maybe we should be moving behind just harm repair and really start taking world making seriously, given the inherent political space that complex reparations will occupy. And it's not just one issue, it's not just one climate issue or decolonization, it's actually a set of interrelated, interconnected, multidimensional issues. And so I look forward to the next wave of research and collaborating further from the standpoint of our reparations lab. And please permit me to extend my gratitude to the Inter-American Commission of Human Rights, our co-sponsors for this webinar series, as well as the Max Planck Institute of International and Comparative Public Law, and turn over to Anibal for any final remarks before we close.
No, my last point is that I also want to thank the audience that was with us tonight. Several people sent comments. Francisco Cabrera, for example, sent several comments that we didn't have enough time to address, but I want to thank everyone who followed our presentation today and invite everyone for our panel tomorrow at 6 p.m. ET, Eastern Time, in which members of the Inter-American Commission will discuss the very urgent problem of academic freedom in the Americas. Thank you very much.